serious felonies. Reports suggest that even old DUI convictions from years or decades ago, minor drug possession charges that were dismissed, or misdemeanor offenses that you thought were behind, you could now trigger deportation proceedings that end your permanent resident status and force you out of the country. What makes this case different is the administration's aggressive reinterpretation of existing immigration law and the deployment of advanced database systems that can identify green card holders with any criminal record going back to when they first entered the United States. The landscape of immigration enforcement has shifted so dramatically that legal permanent residents who have lived in America for 20 or 30 years, raised families here, and built entire lives could suddenly find themselves in removal proceedings based on incidents they believed were resolved long ago. If you are interested in this topic and liking this video, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. The Trump administration has made clear that immigration enforcement is the top priority for 21-26, but what's emerging now goes far beyond targeting undocumented immigrants or recent border crossers. According to sources familiar with the Department of Homeland Security's enforcement strategy, Immigration and Customs Enforcement, ICE is building specialized task forces with one specific mission: identifying and deporting green card holders who have any criminal convictions on their record, no matter how old those convictions are or how minor they seemed at the time. Officials argue that this crackdown is necessary to remove criminals from American communities and that legal permanent residents who violate the law have forfeited their right to remain in the country. The administration claims these operations will focus on violent offenders and serious criminals who pose genuine public safety threats. However, immigration experts note that the criteria being used to identify deportable green card holders are so broad that hundreds of thousands of people with minor offenses, old convictions, and cases that were dismissed or expunged could find themselves targeted for removal. In practical terms, here's what you need to know about how this crackdown could affect you if you're a green card holder with any criminal history. Immigration and Customs Enforcement is reportedly implementing enhanced cross-referencing systems that connect immigration databases with federal, state, and local criminal justice databases going back decades. What this translates to is that ICE agents can now instantly identify green card holders who have any arrest record, any criminal charge, any conviction, or even any dismissed case anywhere in the United States at any point since they received their permanent resident status, or even before. Once identified, these individuals can be placed on priority removal lists, taken into immigration custody, and processed through deportation proceedings at unprecedented speed. The following categories of green card holders are facing heightened deportation risk under these new enforcement operations. First, anyone with a DUI conviction, regardless of when it occurred or whether it was classified as a felony or misdemeanor by the state court. DUI offenses have always been problematic for immigration purposes, but what's changed is the administration's interpretation of these convictions as crimes involving moral turpitude or aggravated felonies under federal immigration law. Immigration attorneys across the country report that green card holders with single DUI convictions from 10 or 15 years ago are now receiving notices to appear before immigration judges. Even cases where no one was injured, where the blood alcohol level was barely over the legal limit, or where the individual completed probation successfully, are being pursued for deportation. Second, any drug-related offense, no matter how minor, puts green card holders at extreme risk. This includes possession of small amounts of controlled substances, possession of drug paraphernalia, or even situations where charges were dismissed after completing a diversion program. So, while there's a narrow exception for simple possession of marijuana under 30 grams as a first offense, immigration officials are interpreting this exception as narrowly as possible. And honestly, any second offense, any amount over 30 grams, or any drug other than marijuana makes you deportable under current law. Legal analysts suggest, the administration is actively looking for green card holders with any drug history to initiate removal proceedings, and these cases are being prioritized for rapid deportation. Third, domestic violence convictions or violations of protective orders are triggering automatic deportation proceedings for green card holders. Under federal immigration law, crimes of domestic violence, stalking, child abuse, child neglect, or violation of protection orders are deportable offenses, regardless of whether they were classified as misdemeanors or felonies by state court. What many green card holders don't realize is that accepting a plea deal to a domestic violence charge, even if it meant avoiding jail time, created an immigration time bomb that can explode years later. Immigration experts note that the administration is using enhanced screening at ports of entry, routine IC check-ins and background checks during green card renewal to identify individuals with these convictions. Fourth, any conviction classified as a crime involving moral turpitude within 5 years of admission to the United States or 2 or more crimes involving moral turpitude at any time makes green card holders deportable. The problem is that crimes involving moral turpitude is a vague legal term that immigration authorities interpret extremely broadly. It can include theft offenses regardless of the amount stolen, fraud charges even for minor misrepresentations, assault offenses where no serious injury occurred, and various other crimes that don't seem particularly serious in criminal court, but are treated harshly under immigration law. Immigration attorneys warned that green card holders who accepted plea deals years ago without understanding the immigration consequences may now discover that those convictions make them removable. Fifth, aggravated felonies under immigration law create the most serious deportation risk and offer almost no possibility of relief. Despite the name, aggravated felonies under immigration law don't have to be classified as felonies by state courts and don't have to be particularly aggravated. They include theft offenses where the potential sentence was 1 year or more regardless of the actual sentence served, drug trafficking, including simple possession with intent to distribute, crimes of violence where the potential sentence was 1 year or more, fraud offenses involving more than $10,000, and numerous other categories. Once immigration authorities classify a conviction as an aggravated felony, the green card holder becomes ineligible for almost all forms of relief from deportation, including cancellation of removal and voluntary departure. To put this in perspective, the deportation process for green card holders with criminal convictions moves much faster than most people expect. Once ICE issues a notice to appear, which is the document that initiates removal proceedings, the green card holder must appear before an immigration judge. Unlike criminal court, where you're entitled to a court-appointed attorney if you can't afford one, in immigration court, you have no right to free legal representation. If you can't afford to hire an immigration attorney, you must represent yourself against a government prosecutor who handles deportation cases every single day. The immigration judge will review your criminal history, examine the specific convictions on your record, and determine whether those convictions make you removable under immigration law. If the judge finds you deportable, you then have the burden of proving you deserve discretionary relief from removal, which requires showing extraordinary factors such as American citizen family members who would suffer exceptional hardship if you're deported. Beyond the direct deportation proceedings themselves, the administration's crackdown is creating a climate where green card holders with any criminal history are being detained during their removal proceedings rather than being released on bond. Immigration and Customs Enforcement has significantly expanded use of mandatory detention provisions that require green card holders with certain convictions to remain in immigration detention facilities throughout their court proceedings, which can last months or even years. This means individuals who have been living freely in their communities, working, supporting their families, and complying with all conditions of their criminal probation suddenly find themselves locked in detention centers, unable to continue their normal lives while fighting deportation. The real question is what this means for the millions of green card holders who made mistakes years ago, served their sentences, completed probation, and believed they had moved on with their lives. Immigration experts note that under current enforcement priorities, past criminal history that was previously overlooked or considered too minor to pursue is now being used as grounds for deportation. Green card holders who have been in the United States for decades, who entered the country as children, who have American citizen spouses and children, who own businesses and employ American workers, are being placed in deportation proceedings based on convictions that occurred 20 or 30 years ago. Despite these challenges, it's important to understand that not every green card holder with a criminal record will be deported. There are forms of relief available in certain circumstances, though the administration has made these forms of relief much harder to obtain. Cancellation of removal for permanent residence requires showing you've been a permanent resident for at least 5 years, you've resided in the United States continuously for 7 years after admission in any status, and you haven't been convicted of an aggravated felony. If you meet these requirements, you must then convince the immigration judge that your positive factors such as family ties, community involvement, employment history, and rehabilitation outweigh the negative factors of your criminal convictions. Legal analysts suggest immigration judges are denying cancellation of removal applications at much higher rates under the current administration's enforcement priorities. While there have been some modifications in how different administrations approach deportation of green card holders with criminal histories, the current focus on aggressive enforcement, even from minor old convictions, represents a fundamental shift. Previous administrations generally prioritized deportation of individuals with serious violent felonies, recent convictions, or multiple criminal offenses. What's different now is that single DUI convictions, old drug possession charges, misdemeanor domestic violence cases, and other offenses that wouldn't have triggered deportation proceedings under previous policies are now being actively pursued. Advocacy groups warned that this crackdown will devastate immigrant families and communities across the country. They point to cases of green card holders who came to the United States as small children, who have lived here for 40 or 50 years, and who have no connection to their birth countries, being deported based on decades-old convictions. Civil rights organizations argue that using minor criminal offenses as grounds for tearing apart families, well, it violates principles of proportionality and fairness. However, before jumping to conclusions about whether these policies will be scaled back, it remains to be seen whether public pressure or legal challenges will cause the administration to modify its enforcement approach. As a green card holder watching these developments, this situation might feel terrifying, especially if you have any criminal history in your past. The most important thing you can do right now is consult with an experienced immigration attorney immediately. If you have any criminal convictions, arrests, or even dismissed charges on your record, an attorney can review your specific criminal history, analyze whether your convictions make you deportable under current law, identify any potential forms of relief you might qualify for, and prepare you for how to respond if ICE attempts to take you into custody. Do not wait until you receive a notice to appear to seek legal help. By that point, your options may be severely limited, and the deportation process may already be in motion. It's also critical to understand your rights if immigration agents approach you. You have the right to remain silent, and you have the right to speak with an attorney before answering any questions. If ICE agents come to your home, you do not have to open the door unless they have a warrant signed by a judge. If they do have a warrant, you should comply, but immediately contact an immigration attorney. Do not sign any documents, do not agree to voluntary departure, and do not make any statements about your criminal history or immigration status without first consulting with legal counsel.